Mr. Speaker, I rise in support of Justice McDonald's nomination. And I also, like many of us on the Judiciary Committee, sat through the 13 hours of questioning that he received. Could hear his temperament, could hear him answer every question that was posed to him, and listen to him explain time and time again why he did not recuse himself on the Santiago decision or on some of the other questions that have come here today. I'd like to put this debate back into context if we can. I counted. There was over 2 hours of questioning on the Santiago and the Santiago recusal alone during the Judiciary Committee public hearing. We've heard on the floor today comments such as that there was a perception he may have bias, that he should have recused himself. Maybe he should have. Fair minds may disagree, that we have evolving standards of where we were going, and that our rules are rock bottom, bare minimum. However, as Justice McDonald explained time and again during his confirmation hearing, that is not the law. That is not the rule. He must follow the rules, and he must follow precedent. And one of those rules is found in the Judicial Code of Conduct, Rule 2.7. There may be folks who don't like Rule 2.7, but it exists, and it's the rule that was in place when Justice McDonald had to make that decision that day whether to recuse himself on the Santiago decision or not. Rule 2.7 is clear that a justice must sit on a case unless there's grounds for recusal enumerated under the remaining rules. They are required to sit. There's a reason for this. The reason is exactly what is happening here today. The reason is that the dignity of the court, as the commentators' comments to the rule say, the dignity of the court, the judge's respect for fulfillment of judicial duties, and the proper concern for the burdens that may be imposed on the judge's colleagues require that a judge not use disqualification to avoid cases that present difficulties, controversial, or unpopular issues. I think anyone who knew they were going to sit on Santiago knew it was going to be a controversial decision. It was probably one of the most significant and most controversial cases that has gone through our Supreme Court in quite some time. Perhaps as we sit here today and continue to debate this, Justice McDonald wishes he had been able to recuse himself from that decision. He was not. We may have the opinion that he should, or we would have liked him to, or the like, but that is not the rule. He followed the rule. He followed precedent. And you don't have to take my word for it. The most authoritative comment that we've received is a letter dated March 6th, 2018, from a former Associate Dean of the University of Connecticut School of Law and one of our state's leading experts on legal and judicial ethics, Professor Leslie Lewin, the Joel Barlow Professor at Law at the university. In an artful 4-page letter that was sent to legislative leaders and all the leadership of the Judiciary Committee, she went line by line through Judicial Code Rule 2.7 and affirmed that Connecticut judges have an affirmative obligation to hear cases under that rule, and that based on that rule, Justice McDonald should not have disqualified himself from hearing the Santiago case. She refuted the notion that his pre-existing views somehow are grounds for recusal. She recognized that every judge comes to the bench with pre-existing views on a number of issues, be they on the right, the left, or down the middle. She refuted that by participating as a legislator in the passage of Public Act 9-107, which was the death penalty bill of 2009, that somehow that was a reason for disqualification. It was not. She went through several instances where judges who have served as legislators have ruled on cases, including the fact that then Associate Justice Borden frequently decided cases interpreting our criminal statutes, which he helped to draft. Justice McDonald, during his confirmation hearing, cited to this treatise over and again. This is the leading treatise on recusal and disqualification of judges, which he cited to. And on this point of whether prior service in the legislative branch is grounds for recusal, it summarizes that most of the courts that have had the occasion to consider the matter, however, have found disqualification to be unwarranted, even if the challenged judge, while in the legislative branch, was involved in drafting, sponsoring, or promulgating a statute or procedure that later becomes before the judge for review, so long as the validity of that statute or procedure is a question of law. And for this reason, and some others, no doubt, about the judge's ability to be impartial, the handling of the case has arisen. She, recognizing that authority and others, including Supreme Court precedent involving Justice Black ruling on the constitutionality of the Fair Labor Standards Act and others, found that is not a grounds for recusal. Finally, this issue of what Justice McDonald did or didn't do in 2012 as a member of the administration, she found to be immaterial. She concluded that even if he had expressed views and been involved in that legislation, it was not a ground for disqualification. She analyzed Connecticut Judicial Conduct Rule 2.11(5)(b), which requires disqualification when the judge's prior employment participated personally or substantially in that particular proceeding. Justice McDonald took no part in the Santiago proceeding. She concludes that nothing about Justice McDonald's participation in Santiago is grounds under our law, under our procedure, under our precedent for having to recuse himself in Santiago. The professor's opinion is backed up in large measure by Law Tribune articles that have been written, including that of Wes Horton, Attorney Wes Horton, who is probably the most prominent appellate practitioner in the state, is a registered Republican and was Tom Foley's lawyer several years ago in a case that came up. He cited case and case again. In the interest of time, I will not go through them, to show what he concludes is that, quote, Justice McDonald is a centrist judge with whom all legislators should be comfortable. The cases that he has authored, he says, are not always predictable. He will just as often vote, in this, he means he will just as often vote with the conservatives as he does with the more progressive members of the court. It's worth noting that Justice McDonald, while in this legislature, was the chief author and advocate for Connecticut General Statute 1-2Z, which requires justices to look at the plain meaning of a statute before all else, overturning prior Supreme Court precedent. On Santiago, as discussed, not only could Andrew McDonald not have recused himself given our precedent, nobody asked him to. We talked about the chief state's attorney. We talked about the role he played previously. That was all known. That was all public. At no point did the chief state's attorney or anyone else say Justice McDonald should recuse himself. That suggestion did not come up until well after the case was heard. There was never a motion. There was never any public suggestion prior to the decision being reached. Another misnomer we've heard today is that Justice McDonald was somehow the swing vote on the Santiago case. In fact, there were 3 other justices who joined with him. Justice McDonald did not author that opinion. Justice Palmer did, who this legislature confirmed for another term a year or so ago. The other 2 members of the court who voted with the majority in Santiago were Justice Norcott, who co-authored the concurring opinion we've heard about today. He passed this chamber unanimously last year. The final member of the court was Justice Everly, a Jody Rell Republican appointee who earlier today cleared this chamber with over 100 votes in the affirmative and only 30 opposed. Justice McDonald is the 4th member of that. The other 3 have been reconfirmed by large majority and have moved through this chamber over the last couple years without this level of scrutiny, without this level of questioning, and without looking outside what they should or should not have done on that decision. A final point I would like to make, and that is that it's been suggested here today that a no vote, that not confirming Justice McDonald would not do long-term damage to our bench. I'll submit to you I disagree. I think that if we continue to zero in on one decision, 2 decisions, 3 decisions, and we second guess whether under our existing law and our existing precedent, whether someone should recuse themselves because we might have liked them to, not because they were legally required to, but because we might have liked them to, that we are doing long-term damage to our judicial branch, that we are putting every judge in the state of Connecticut in a position of looking over their shoulder, thinking, is this the right decision based on the law and the facts before us, or is this the decision that the legislature would like me to pass so that I can get reappointed for another 8-year term? I ask you to consider that as you vote this afternoon.